of Science, Justice of the Supreme Court of Sierra Leone, and the Honorable Justice Ansumana ICC.
May it please you, Lord.
I note that you're on the left-hand side instead of the right-hand side. Why this unilateral change?
The Lord is not a unilateral. The Lord, representing the plaintiffs in this matter, Dr. Abdullahi O. Conte, who is on his way. Joseph Fitzgerald Kamara. Adi Makuri. Ibrahim Kamara. And Karu Kamara. A. Karu Kamara.
My lords,
Hello.
yes, is present the Attorney General and Minister of Justice. Representing the first respondent is R.B. Kowa. O.I. Kano. O.I. Kano. Usman Ibrahim. Yes. Kano. A. Supindo. MP Bangura. Then what? P. Bangura. C.J. Freeman. F. Moibula. A. Boyman. K. Sandy and A. Lansana. K. Sandy and A. Lansana.
For the second respondent.
Yeah. Dr. E.S. Abdullahi. A.T. Ture. A.T. Thomas. And J.A. Walker. For the second respondent. A.T. Ture, Dr. E.S. Abdullahi. A.T. Ture and J.A. Walker.
What is it?
Yes, sir.
Is the respondent?
Second respondent. Representative of the Electoral Commission is here. The Electoral Commissioner himself is here, Mr. Mohammed Kone. And
few other commissioners. Commissioner Ture.
Could somebody make way for him to sit down? Should not be on there. You sit at the back, you're not the lawyer, so just sit at the back. Are the plaintiffs present?
Yes, my lord. We have Honorable Abu Hamid present. And
First plaintiff present.
yes, second plaintiff is also present. Councillor Akiratu Action Oka.
Sit down. Thank you. Yes, Mr. Septima.
Lord, may I crave the indulgence of the court that counsel on the record is on its way, Dr. Abdullah Coulter. The notice we received is that the court will commence at 10:30, and I've just spoken to him. He's within the princess, and he should make the arguments on behalf of the plaintiffs.
The court, Registrar, is that the case?
Yes, my apologies. I just saw the notice of the hearing this morning. My apologies, ma'am. You indicated that it should be at 10 a.m. in 1 hour. It is a typographical error. My apologies.
That is sloppiness as far as I'm concerned.
Exactly, ma'am.
That is sloppiness.
My Lord, Dr. Abdullah Coulter is here already. Thank you very much.
Madam Mayor,
Yes.
first humble and profuse apologies. There has been some miscommunication. I got notice for 10:30 for the start of proceedings, and then there was an announcement to say 10 o'clock. But I gave preference or credence to the official notice for 10:30 for proceeding.
Your apology, I accept it. It's not a fault, so you can proceed.
I'm grateful. My Lord, may I just deal with some housekeeping matters. After the lodge of the plaintiff's case, we subsequently received a reply by way of case for the defendant. And in it, they attempted to raise objection to your Lordship's jurisdiction. We are prepared to meet that objection if you do raise it formally before the court and to reply to it. So by way of procedure, may I respectfully suggest that we deal with the, in quotation mark, the objection invoking section 53, subsection 3 of the Constitution as a shield against the Lordship's jurisdiction in this matter. We are prepared to deal with that, and then, if needs be, we go into the substantive.
Jurisdictional objections to be done. If they raise it in the defendant's case, it only behoves you to address it, because this is we are invoking the original jurisdiction of court.
Thank you.
And as a result of that, there will not be any opportunity for replies. So in addressing their case, you need to address it, if that's the case. So we give you time to do that. That's all we can say.
So we can go into our substantive application.
Yes, you know what they've written, and you can address it. Because I'm not going to give you an opportunity to reply. You have one bite, you exhaust your bite by being exhausted.
As your Lordship, please.
It's part of their case.
It's part of their case, and it is part of the plaintiff's case as well. We had anticipated they would raise something like that.
In terms of timing, I am going to allow you time to do what is needful. The only thing is that if giving, say, 1 hour to, or you take 1 hour, the other person too might have the opportunity of going as much as that for equality of arms purposes. But I'm not going to constrict you or constrain you in time like 30 minutes or 1 hour or whatever. So feel free and go into your place.
My Lord, I'm grateful for any guidance and words of wisdom that we forth from the Lord's feet. May I, before I proceed, make an observation and a humble request, given the nature of the case and the issues to be determined. It had been the plaintiff and their attorneys' desire that your Lordship would sit on bank with the full complement of the Supreme Court, and if need be with the Court of Appeal. But I noticed from the panel, a judge or two from the Court of Appeal have been brought up, and there are substantive Supreme Court judges who have not been empaneled. We will, in the interest of justice and given the importance of the issues, wish that this court sat on bank, full bench, to hear the case and determine it, given that it is the apex court.
Well, that is...
I mean, no reflection on the present composition, but just in the interest of justice, so you all with your wise heads knock together.
In so far as paneling of cases are concerned, that is prerogative of the Chief Justice.
Absolutely.
It is you don't know my judges, I know my judges that I've chosen. No disrespect for those that are not chosen. You have to go by it. I am not going against any law, it's the law of the land, and we go by it.
My Lord, I mean no reflection, none in the least, on any judge who's not been empaneled. But we are only saying on behalf of the plaintiff, given the importance of these.
You're all legal jurists or jurists of the law, and it's left with you. If you want to go by the American system where you...
No, it's not an American system.
It's mostly the law.
My Lord, if I may, in the recent decision of the United Kingdom Supreme Court on an application which I cite in my authority, the Chief Justice empaneled in the Supreme Court not less than 11 judges. Because of the importance, this was a challenge to the exercise of the prerogative to prorogue Parliament. And Ms. Miller brought a constitutional challenge. And the judge, or the Chief Justice in the UK, properly effect.
Dr. Abdullah, out of respect to you, to your age, in fact, I was keeping in your class, law of evidence. I've allowed you, but let us go within the law and let us proceed.
My Lord, I have no doubt. It is your prerogative to empanel a court. But that prerogative must be informed by the interest of persons. That's all I say. I move up here. May it please the court. This application before your lordships this morning is by way of notice of originating motion, filed on behalf of the two plaintiffs in the matter, seeking the following reliefs. 1. A declaration that on a proper and purposive interpretation of Section 38A of the Constitution as amended by Act No. 15 of 2001, the controlling provisions stated in subsection 1 of that amendment, namely, and I quote, but no constituencies have been established, are, in our respectful view, conditions precedent to warrant or justify the holding of any general election, particularly for the ordinary members of Parliament, by the district block system referred to as proportional representation. Therefore, any directive by the President to the Electoral Commission to hold any public elections for ordinary members of Parliament
what is in the motion paper, giving us the first relief, grade 4, but the second, I note that you just went there, and I have there as number 2. So are you changing that?
I'm just dealing with the application and the relief being sought by the plaintiff.
You have number 2.
Number 2, the declaration by the Honourable Court that the 5th Parliament of Sierra Leone, as presently constituted, is itself elected on a constituency basis as provided for in Section 3, Section 38, Section 1 of the Constitution. And that these constituencies are still extant and subsisting. That's a relief the plaintiffs are seeking from your lordships. The third relief they seek is that a further declaration that revision of constituencies as provided for in subsection 4 of section 30 does not in and of itself necessarily result in the establishment or dissolution of constituencies stipulated in sections 38 subsections 1 and 2. But rather, the section provides for the period when existing constituencies should be reviewed, which review or revision may or may not necessarily result in a delimitation of the respective boundaries of the existing constituencies. When you hold a review, don't disestablish a constituency. Fourthly, a declaration by this honorable court that will hold the 2023 elections of ordinary members of parliament on the district block system or the proportional representation system for ordinary members of parliament may prevent independent candidates from contesting. May I say to add, I have no brief for anybody who intends to contest as an independent candidate, but it is a provision of the Constitution that contemplates and provides for them. As provided in section 77, paragraph M of the Constitution. My Lord, I begin just with my own, default position. When I say the Constitution, I mean, of course, the National Constitution enacted in 1991. I don't need to go up number this, number that. It is B, as my learned friend used the Kelsenian word, the Grundnorm, which is the highest law as provided in section 171 of the Constitution itself. The plaintiff seek also a fifth declaration that to hold the multi-tier elections in June 2023 by the district block proportional representation system will be unlawful and ultra-violate the Constitution of Sierra Leone as amended. Sixthly, the plaintiff seek from your lordships.
Dr. Loikonte, I hate to stop you, but then you have sent your motion papers, your native notice of motion, which we have. I want it verbatim as it is recorded in the these are the reliefs that you're seeking. And it does not appear you're going by that, it appears that you have your own set of papers which you read, and it does not make for a smooth following of the events this morning. I have to constantly go through it to decipher where you are heading for or where you're going. These are motion papers that were sent long before, and we need to go strictly by that. If you are calling for an amendment, you have to make the necessary application.
My Lord,
I don't know for my colleagues, they may wish to.
yes, Dr. Conte. Dr. Conte. Yes, my Lord.
There are 9.
9 reliefs.
9.
Yes.
I was expecting that maybe for coherence, you would have just referred to 9 rules and then proceed. There's no law which says or rule which says you have to start with the first rule. But I was expecting that every council has its own style or approach when it comes to making submissions on the various rules. When we use that before us on paper are 9 rules. So are you going by 9 rules? Or do you intend to go by some and go by some? Or you are proceeding on all the 9 rules?
To put the case completely. I take what your lordship and the Chief Justice said. That was my style when I was at the bar, even when I sat on the bench. I take the papers as having been read. but a recent experience in this very court by one of the learned brothers. He wanted me to move the motion. I said, I thought you were right. He said, no, move the motion. That's my present insistence or attempt to read the motion is born of that experience in this very court. One of your brothers who was the presiding judge is now on the panel. Stopped me and said, no, move the motion. I said, my brother, I thought you were ready.
Well,
I take it you've read it. Then I can...
That is one, we read it. But then, if you want to read it, read what is in the motion, please. That all of us concerned do have before us. The one dated 28th November 2022. Even if you're going to read it, it does not appear there. That is what you read.
I'm grateful, Madam, but my present posture is informed by my experience at the hands of one of your learned brothers. I was used to it when I was at the bar here, and when I sat on the bench in other jurisdiction. I take it before I go to court. I've read the papers. Council move and let go.
It makes good information for everybody here present if you read it. So that's why it's there. If you're going to adopt the attitude of reading it, the practice of reading it, it has to be verbatim of what is stated. Perhaps your colleague is in a better position to help you.
Well, I am relieved and heartened to hear your lordships have read the motion. I'll move on now to our substantive case.
Okay.
My Lord, before I move forward, may I, again with your indulgence, state at the outset what this case is not about. This case, we say respectfully, is not about the merits or the demerits of proportional representation system of voting. We note learned counsel for the defendant has prayed in aid without any evidence, anything, that it is a system practiced by the majority of member states of the United Nations and most of the stable democracies in Scandinavia. We have no evidence of that. We are not attacking the merits or the demerits of proportional representation as a system of voting. At the heart of this case, as outlined in the case of the plaintiffs, is the crucial issue of whether or not the 2023 elections for ordinary members of parliament and for councillors of respective votes in local authorities, whether or not, that's the crucial issue, whether the multi-tier elections for 2023 should be held on a proportional representation basis. That is what this case is about. And this issue, this crucial issue, in our respectful submission and view, strikes at the very heart of the rule of law. That is to say, whether we as a country are governed by the rule of law. This is a litmus test in our respectful view in this case. I hasten to add and to make clear that by the laws of this country, particularly its highest law, the Constitution 1991, as amended, proportional representation system of voting is not, and I emphasize, it's not an alternative system of public elections in this country. It is not. When you like to turn it on, turn it off. No. Section 38A, which introduced proportional representation system of voting, in the Constitutional Amendment Act of 2021, of 2001, no, 15 of 30, provide pertinently as follows. Just read it, it's plain and simple. Where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established. Emphasize, but constituencies have not been established in accordance with subsection 3 of section 38. For the purposes of such elections, the President may, after consultation with the Director of the Electoral Commission, direct that such elections shall be conducted on the basis of the existing districts in a manner to be known as the district block system instead of national representation basis. It is therefore reasonable to conclude that the system for electing ordinary members of parliament is on a constituency basis, and section 38 of the Constitution, whose side note reads, not part of the law but for guidance, it's not part of the law, but it is pertinent.
It is therefore reasonable to
conclude that by the constitutional scheme, the election of ordinary members of parliament shall be on a constituency basis, not district law, not proportional representation, on a constituency basis. And the side note to that section reads, constituencies and elections. And the section provides magisterially as follows. Sierra Leone shall be divided into constituencies for the purpose of electing the members of parliament referred to in paragraph B of section 1 of section 74. That is to say, ordinary members of parliament. As the Electoral Commission, acting with the approval of Parliament, signified by resolution of Parliament, may describe. It is therefore respectfully submitted that the power granted by section 38A amending the Constitution to the President to direct elections to be held on a proportional representation basis. It's not, I emphasize, it's not entremêled or freestanding. For that matter. That is to say, that power granted the President must be exercised lawfully within the parameters of the Constitution, the highest law. That is to say, exercised within the context stated in the Constitution itself, in the section itself, where no constituencies have been established. We think that is a controlling provision before the President appears or direct the Electoral Commission or anybody for that matter to hold public elections in this country like the proportional representation system. And the section itself states the conditions within which and subject to which the power may be exercised, namely where no constituencies have been established. This case is not about the limits of that power or when it can lawfully be exercised. This case is about the bigger power. It's about the limits of that power when it can be lawfully exercised. And this case, I was running ahead of myself, anticipating the question for my friend. This case is not about any advice given to the President or any authority which by section 53 subsection 3 is shielded from review by any court with respect including your Lordship's court. That is constitutional provision. We are not challenging any advice given by any person, be it the Electoral Commission or any other person. We are saying the directive to order the Electoral Commission to hold the June 2023 elections in this country on proportional representation basis in the circumstances that now exist. I'll come on to this shortly. Would be unlawful. So it's not, I'm glad you're not asking me to go on with the case, not to deal with the question of my line friend. I came prepared for that as well, but I took it, I had anticipated it. It was, with respect, a misconception of section 53. Section 53, subsection 3, is what your Lordship would call an outstruck clause. It outs the jurisdiction if its conditions are met. And it is one outstruck, courts generally frown on the outsting of their jurisdiction, and it is strictly interpreted. We say in context, 53 is a red herring and must be ignored. It takes no one any further. We are not challenging, we are not querying, we are not asking the Lordship to sit in judgment over any advice given by either the Electoral Commission or anybody to the President. We are saying he's directed to the Electoral Commission to hold the election for June 23 on a proportional representation basis. It's not open with the Constitution itself, particularly section 38A as amended. The conditions stated therein are not as I stand here and speak, present to warrant recourse to that section. The case to respect is plainly and simply about the decision of the Electoral Commission, all based on the directive of the President, to hold the forthcoming 2023 general elections on the basis of proportional representation, rather than on constituency lists. That's all we are saying. We are saying only in that plan, or they are subject to somebody's consultation. Therefore, we say the claim or objection on behalf of the defendant that this court lacks jurisdiction to entertain the case by the plaintiff by reason of Section 53(3) is with respect wholly misconceived and special and simply a gross mischaracterization of what the plaintiff's case is about. Section 53 cannot, in context, bear the weight my learned friend is seeking to place on it. It will crumble under the weight. It cannot bear it. I don't want to be labeled upon, but I bring respectfully to your attention the case of the United Kingdom Supreme Court when they sat on bank on the application of Miller appellant against the Prime Minister respondent. Cherry and others responded. My Lord,
I don't know what the citation.
pardon?
Are you repeating the citation?
Yes, I shall indeed, but we will in due course make copies available. I think copies are available. My learned colleague here has to make copies, if only by way of supplementary list of authority. You have it, my Lord?
Supplementary part of the list of the
supplementary list. It's there. I can recite the title again, the citation.
Have you supplied the website?
The copies?
Yeah.
Yes. Yeah. I mentioned
Even now that you're mentioning it, it's very good for us to have copies.
copies, yes. The registry, I'm told, has copies for your Lordship's perusal.
Where are the copies? Is it there? Copies.
Thank you.
Yes.
My Lord, that case is instructive to
Where should I find that case in this
Pardon?
supplementary list?
For authorities, where could I find that case?
where can you find the case?
Yeah.
It's in the
Yeah.
May I continue?
Yes.
Okay. In that case, the United Kingdom Supreme Court had to examine on an appeal the threshold issue of whether or not prime ministerial advice to the monarch, the late Queen Elizabeth II, God bless her, on the exercise of the prerogative to prorogue Parliament. We have to examine the threshold issue of whether that advice by the Prime Minister to Her Majesty was justiciable or not. Lady Hale, the President of the Court, sitting with a full court, the complement of 11, I think, which means that the judges are listed there, gave the unanimous judgment of the court. She stated inter alia, I just go forward, I refer also to paragraph 33. She started off by mentioning the old chestnut of the Inland Commissioners of Revenue, ex parte National Federation of Self-Employed, the Diplocian dictum in that case. And she continued, it is, in my view, not sufficient answer to say that judicial review of actions of officers of government, department, or other departments of central government is unnecessary because they are answerable to Parliament for the way in which they carry on their functions. They are accountable to Parliament for that, for what they do, so far as the efficiency and policy. And of that, Parliament is the only judge. They are responsible to a court of justice for the lawfulness of what they do, and of that, the court is the only judge. I think that is the lesson and the history we learn. Courts have Parliament fought with the courts to say who is supreme. We have in the UK constitutional parliamentary supremacy. We have here constitutional supremacy. And you, as the plaintiffs have rightly invoked your interpretative jurisdiction to determine, it's only to you, everyone is answerable. Nobody can ask the power to do that, to review whether any action taken by the government, the president, with respect is lawful or not. He cannot himself determine it. He cannot preclude you from determining it. And in the context of this case, Section 53 cannot, I say cannot, avail. We are saying that decision is not lawful, it's not within the parameters of Section 38A as amended. And your Lordship, this court is the only judge for that. No one else. And nobody can take that jurisdiction from you, which the supreme law of this country has granted you. Not to the President, not to Parliament, but to your Lordship, sitting in your interpretative capacity, pursuant to Section 124 of the Constitution. Your original and exclusive jurisdiction. Nobody else can exercise. No authority. Only you. Not even the President himself can say, I make it, I say so. No. This is not a country, if I may use the aphorism of Humpty Dumpty, where Humpty Dumpty said, what I choose them to me. The question is, who is master? We don't live in that country, or such a country. and it is your lordships, it is your task in this case. We urge you vindicate the principle of the rule of law. That is what the plaintiffs are seeking at your hand. What does the law say? Not what anyone says, however high and mighty you may be. Does it accord with the law? That's what we're asking you to interpret. And I adopt with approbation, if I may, and respectfully order this court, the statement by Lord Hay as President in the case I just referred to. And I quote, "The court will be performing its proper function under the Constitution, indeed, by ensuring that the government does not use the power of prerogation unlawfully with the effect of preventing Parliament from carrying out its proper function. The court will be given effect."
The Bible.
What was the formula? I didn't mark your copy. I wanted you to read that because I said, but I think it's after that which I did.
Yeah, the good show.
And if I may, and we say so respectfully, this court will be performing its proper function by ensuring that the President does not direct the Electoral Commission to hold the forthcoming elections in the country on a proportional representation basis, when the underlying conditions for that are not present. We have constituencies in this country as I speak. I'm not sure if Parliament is sitting today, but if you go there and pull out any member of Parliament, he will readily tell you, I represent constituency this or that. There are constituencies. You cannot, in the face of that fact, irrefutable fact, if I may say so, order general elections to be held on a proportional representation basis. We'll be thrashing our constitution, the rule of law, and if I may say so, democracy. The MPs are voted by members of Parliament. As I said, this case is not about the merits or the demerits of proportional representation, but one of its glaring a chink in its armor is the voters don't vote for candidates. They vote for a list submitted by political parties to the Electoral Commission. And they get MPs in the order in which their names appear on the list. Voters want to say, this is my MP. I know him, I voted for him. Not some faceless, somebody I don't know, whose name happened to be on the voters list, or on the candidate list of the Electoral Commission. That is not democratic. But as I say again, it is not about the merit and the demerit. I just say it by way of an aside and I move on. We say there are two conditions precedent which must be satisfied to bring Section 38A and its proportional representation system into play. The first is a date for the general elections of members of Parliament has been appointed. And two, no constituency
Thanks.
I'm not sure if EXA has artificial intelligence or human intelligence that is not applicable. I say no more. The first condition is when a date has been announced for the general election of members of parliament. And the second is no constituencies have been established in accordance with 38(3) of the Constitution. Then, and only then, can the president direct or have recourse to proportional representation basis. We say the determination of these two crucial issues is on the evidence and analysis of the law. Namely, whether a date has been appointed for the 2023 general elections, and secondly, whether there are present or not present constituencies in this country at this present time. And we say again respectfully and resoundingly, the answer must resoundingly, yes. Date has been announced, and there are, as I speak, if Parliament is sitting, members of Parliament representing constituencies. Excuse me a moment. It is a fact, we dare say, that the press statement, which is already in evidence before you in the affidavit of the first plaintiff, the press statement of 21st October 2022 by the second respondent, the chairman of the Electoral Commission, 24th June 2023, has been set for the general election. It's a fact. So the date has been announced, the date has been set, the first condition has been satisfied. It is also a fact, as evidence, we just don't say or make a reference, but it is before you, that the first plaintiff represents, Honorable Mr. Abdul Kabu represents a current and existing constituency in the present 5th Parliament of Sierra Leone. That's a fact, it's from the name, irrefutable. So there are constituencies, and it says on oath, I am a sitting member of Parliament. I represent a constituency in the, I think, Kafibulon Lungu Local District. Nobody can deny that. Nobody can say that constituency does not exist. However, we say and I say it with some regret, there is no countervailing evidence, not even a scintilla of evidence from my learned friend on the other side to refute what is the evidence put forward by the plaintiff, that the plaintiff, first plaintiff is a member of parliament, the second plaintiff, Mrs. Cocker, represents a ward, so there are constituencies, and nobody can deny that. She was elected in the last election, and that ward is still in being. She gives the number of ward which she represents. And I respectfully invite your lordships to take judicial notice, as you are entitled to do. The current fifth parliament sitting up in Tower Hill is constituted by members of parliament representing existing constituencies. It's not that we have a blank slate. No one there. These internally displaced citizens, for these persons, they are all over the place, they are not in their constituencies, no. There is no evidence, none at all, not the slightest, from the defendants to contradict these irrefutable facts that are put in evidence on behalf of the plaintiff. We therefore say respectfully that any decision to hold the general elections of 2023 outside the parameters of Section 38A of the Constitution would be unlawful in the face of the evidence and the law. It would not be lawful. There are constituencies. A date has been announced. Ergo, no PR will go by Constitution. In fact, that is the default position of this country since 1962, soon after independence. And even before, when we had a multiplicity of political parties, the people of this country have been used to trundling out to polling stations to vote for their candidate, not for parties, for their candidate. The candidate will represent parties, but not by list. That has been the history. And it was the same until the unfortunate events in April 1992, when regrettably this country lost its way. Civil war compounded by water, and the population was destabilized. Communities were upset, uprooted, scattered all over the country, some to refuge abroad, and those that stayed had a harrowing time. When, before the military government itself, the military junta, in the interregnum before they stepped down from office, passed a decree which introduced proportional representation system. And this was validated by President Kama when he brought in the constitutional amendment which gave us Section 38A, which provides for proportional representation. 38A was the product of its time, coming from a war-torn country with destabilized people, no settled communities, let alone constituencies. Let's have the elections and proportional representation. Everybody went along. 1996 was proportional representation. 2001, I believe. 2000. I wasn't there to speak to you about that. 2002 was again proportional. Given the recent experience of the country. But But since then, my lords, nobody can deny this, we have settled savagely to constituency elections. And the immediate past 3 elections in this country have always been held on constituency basis, including the 2018 election, which constituted the present parliament. It was on a constituency basis. Are we coming back to those dreadful days when our citizens are poor citizens who are displaced and their communities upset and no constituency? God forbid. And your Lordship do so for us. We do have constituencies. God forbid. May they continue to be in vain as a mark of our stability as we march on the highway of democracy. We do have constituencies, not proportional representation. We say respectfully again, it should be in the most unusual and exceptional circumstances, envisaged and stated expressly in Section 38A of the Constitution, that could justify the resort to a proportional representation system. No constituencies exist. God forbid. We hope the tender shoots of our democracy that have sprung up will thrive and survive. And like bulbs, will never die. Winter may come, rainy season may come, but in the springtime, in the rain, we sprout again. Our democracy will sprout again to march on, to consolidate the stability and peace of this country. Let us not go back to the bad old days, which Section 38 implies. No constituencies have been established. May those days never come again. It is, my Lord, I say this with some diffidence, but it's important to note that up to the present, up to the time I'm standing in this court, there has been no reason or explanation given by the defendants or the government for that matter for the to change the form of election. No reason has been given. None. Maybe you are pretty hard enough to nobody has told you, I've never listened to ASLBC to hear it or read in the paper. Government or the Electoral Commission says proportional representation will be for the following reason. Just because of the directive of the President to the Electoral Commission. That is not the law of this country. The law of this country stipulates conditions which must be satisfied. And we say respectfully, those conditions are not present. The first, the date has been set. The second, there are no constituencies. We say that has not been made. There are constituencies. Why now? How many months are elected? 5 months. Some political parties are even in disarray. But time is marching on. But nobody has come to explain to the ordinary suffering masses, ordinary public of this country, why we want to change the system to vote. Other than correct whatever the statement from the Electoral Commission. Why proportional representation around this time? No reason has been given. None from my planet. None. I dare say the electorate and indeed the general public must be confused and wondering why proportional representation this time around. Why? Nobody has explained it. Why? We have a tried and tested method. Some call it first past the post, some call it by constituency. But why go now to a strange creature which we tried in the not so halcyon days after the end of the Civil War? Why take us back? No. And I beg their lordships to say we cannot, without reason. We can only do so if we are within the law, and the proposal to have those elections on a PR basis the proposals do not satisfy the provisions of 38A. There's nothing from the relevant authorities to justify or explain the change of the form of election that would warrant proportional representation. And this is important, my Lord, the powers that be attempted to make proportional representation as part of the general law for public elections in this country. They did attempt. They were obeying the law. They prepared the bill. The Public Elections Act bill. I think we exhibited it in the enclosures of the affidavit of the first December. That's first printing. But in that bill, my Lord, is published in the Gazette. We exhibited it. You look for it. In clause 57 of that bill, I can read what talking to. In clause 57 of that bill, it was provided that public elections shall be a representation of the teaching or proportional representation. But in the debate, when the bill was introduced in Parliament, all hell broke loose. In Parliament, there was a hue and cry by members of Parliament against the proposal in clause 57 to have proportional representation. As part of the laws of this country. My Lord, the proposal never saw the light of day. Clause 57 was not put to the vote. Thank you. Clause 57 never saw the light of day. And the Speaker of Parliament, like the Oracle at Delphi, made a Delphic pronouncement that proportional representation was already part of the laws of this country. It was really the Oracle at Delphi speaking with respect to the Honourable Speaker. The Oracle at Delphi, may not recall, when you are in trouble or want to go on a mission, you go and consult it. It will give you your fortune, but with a conundrum, and that would be to your peril. He would not explain what it is. He just makes an oracular pronouncement. Speaker, the Honorable Speaker made a statement, oh, it's already part of the laws of this country. And indeed, he was correct. He was referring to Section 38A. But as I had said earlier, 38A has conditions. It's not freestanding. It's not like a tap and a faucet. You turn the head, water comes along, you turn it off. There are conditions. A date has been set, two constituencies have not been established. The Honourable Speaker failed to tell Parliament that. And unfortunately, like some unguided wayfarer, those responsible for the election stumbled on their path, on their way, and issued a press release. They say, on the directive of the President, to hold the election on the proportional representation. And the Speaker respectfully failed to tell Parliament there are conditions. They just made the oracular statement. It is already part of our law. It is indeed, but it is not freestanding. Conditions are there in 38 which must be fulfilled before the proportional representation is brought into effect. And they did not, in this case, satisfy those conditions. That's why we are here, respectfully before your Lordship's court, to guarantee the rule of law, to pronounce on it. We are a country governed by the rule of law, particularly the highest law. 38 is these conditions. The date has been announced. No constituency. First, conditions satisfied, but there are constituencies. And on the evidence before your Lordships, there are constituencies and wards. Nothing from my land. Instead, what the act that came out of the debate finally did, it piggybacked as it was Section 38A as part of our electoral rules. But no reference to the conditions in the press statement or the reason. Admittedly, Section 38A of our Constitution, proportional representation is indeed provided for as a form of election. We don't dispute that. Our case is the conditions stated in the very Section 38A are not present, particularly the overriding condition, absence of constituency. There are constituencies currently in the country which constitute the current Parliament of Florida. The case for the plaintiff, 38A, is not self-standing or self-executing. It's not freestanding or self-executing. Therefore, she will be 38A. No, there are conditions on it. We say, and those conditions are conditions precedent, which must be present for the deployment of proportional representation system in this country. And we are not all present, particularly the constituency. There are constituencies. We say unreservedly and with emphasis that this condition, the absence of constituency, is not present now in this country to warrant proportional representation system. And indeed, from the evidence before this court, it is impossible to conclude any reason to warrant the change to proportional representation system in the circumstances of this case. I think if the Americans have a saying, if it ain't broke, don't fix it. Our constituency system is not broken. Why don't you fix it? By a forge, because PR is only a forge. FUDG is a forge. Why do you want to use it? It's not guaranteeing our democracy. It's not enhancing it. And the excuse, I say it's no more than an excuse, by the defendants, that the inability, the excuse, that the inability or the impracticability of the second defendant to complete the division and possible delimitation exercise in the country would warrant holding the next elections on a proportional representation basis. They issued a statement. The revision exercise is immediately stopped. Nobody stopped them.
Please talk to the mic.
My Lord, I really beg your pardon.
You're constrained by time.
Yes, I'm constrained by.
I think before you the way
In my days at the bar, I would walk up and down, paying attention to the bench, of course. When I stand straight, it affects my vasculature. Cardiovascular system. It does affect me. At my age, my Lord, I make
You want to move?
I beg your pardon?
You want to move? Want to be moved?
Exactly.
Well, this is English
I
bar.
read an article.
This English bar is not the American bar. So,
But otherwise, we had no microphone. These contractions were not there. Our voices carried. We had no microphone. I do beg your Lordship pardon for the instruction moving away from the mic. We say it is an excuse. And at best, a lame excuse that would not justify them because of the impracticability or inability, which is not explained. No, it's not in evidence. Nothing is before you, Your Lordship. They started the revision exercise and the limitation as provided lawfully by the Constitution. Within 5 years, not more than 7 years. They embarked on it. They are walking or dancing or marching to a different drum beat. They abandoned it. And to pull the white rabbit out of the hat. Hey, here it is, proportional representation. And no explanation has been given to the people of this country. Nothing has been put forth before your Lordship by way of evidence to justify it. Apart from attorney making, I should be careful about this, my learned friend referencing documents which are not even in evidence. As your Lordship know very well, evidence is that which goes to prove or disprove a fact in issue tendered before a court, either by viva voce or document. None of them. Not even an affidavit from the Electoral Commission. Why we abandoned the revision exercise. And now they trump up it as an excuse, calling it inability, self-imposing ability, self-imposing practicality. Nobody imposes any practicality on them. And it is impossible. It is not true. And the Learned Council put forward. And it is not evident. The midterm census evidencing population changes. We say, and I say categorically, that is not evidence before logic. It's Learned Council's so-called reference document. It's not evidence. It must come on attestation, on oath or affirmation by way of affidavit or waiver voucher from that box and tendered. The Learned Council pleaded to his case for the defendant, and he wants to see that he says, please, disabusing is mandatory. It is not evidence. It is elementary. Evidence is something that is tendered either waiver voucher. Yes.
What is attached to an affidavit?
They are.
Yes. And so if you feel strongly that there is no evidence,
There have to be an affidavit.
sorry, sir. If you feel strongly that there is no evidence according to what you have seen, then you can attest the deponent of the affidavit in your witness box. Do you understand?
It's not evidence.
Sorry.
It's not evidence in the greatest respect. I think there's a copy of it to look up what evidence is in law.
Carry on.
No, is there any affidavit reference in the document? If you were put by way of an affidavit exhibiting them, then they would be properly before your lordship. That is not
an issue of weight. The issue of weight. The issue of weight.
Weight?
Yes, weight. The weight to be placed.
In this case, I respectfully say not an iota of an ounce should be attached to it. It's just a document for what it is for. I won't even read it if I were in a lordship position. Affidavit attached there, then properly.
So, Dr. Conte, you're saying that the court should not consider it at all.
Yes.
As evidence.
Absolutely.
That's the position you're taking.
No.
So the issue of weight does not come.
No, should not be considered. It's just the time and waste of paper. And
It should not even be clean. So I should not even clean it. Meaning, I look at it, have some idea of what it contains, and then I know.
They will be wasting your time if you're to do it. You've been lawyers, you've been attorneys.
I was just going to say to you.
How we use evidence in court. We use evidence by a witness. Who is the witness? Is Learned Council who represents a witness? If it's, I want him in that box.
Just read.
The provenance.
Allow Justice
We are bound by Rule 92. The defendant doesn't have to file an affidavit. Everything he wants to say should be contained in his statement of case. And I think this is what they've done. The defendant doesn't have the right to file an affidavit unless we will allow this in extraordinary circumstances. For instance, in 2018, but strictly speaking, all you have to say, as far as the defendant is concerned, has to be a statement of case. That's Rule 92.
It's not part of their case.
I'm going to that, but all I'm saying is that whatever it is that we should say has to be in a statement of case. I'm going to Rule 92. The plaintiff files an affidavit in support of his motion. and then if I cannot be verifying the statement of case. But the defendant has no duty to file an affidavit. All it does is say whatever it is he wants to say in the statement of case, and then you can reply if you show desire. You reply in paper as well. You can show, of course, as counsel at the back. But then also provide a reply to the defendant's statement of case if, for instance, some issue has been raised there which was not contended by you. So that's all I just want to point out, that there will be an opportunity for whoever filed the statement of case to be cross-examined in the instance.
What was to stop the second defendant as the commissioner responsible for reviewing the limit, making an affidavit and attaching
He can do so in the statement of case.
No, that is the only proper way to do it. Not by counsel putting it in this case.
That's the concept.
It's not evidence. My Lord, I can give you the authority.
The authority is no.
Yes, evidence is a fact issue. Can I go? Thank you. No. My Lord, we're in a court of law governed by the City. That's why it's called a court of law. I'm on the excuse why the second defendant of the inability and the impracticability to complete the revision exercise.
Dr. Abdullah, you made mention of you taking judicial notice. You said you should take judicial notice of the fact that MPs in Parliament were elected on single member constituency basis. Right?
No, well, that's not what I said.
You said you should take judicial notice of the fact that
the current
appointed and elected here by single member constituency form. That was what you said. So we should take judicial notice of that. I'm just saying, if you said we should take judicial notice of that, even when you said there was no reference made in the affidavit, of the midterm population census, so it's not appropriate for us to take judicial notice of that too.
Of what?
The midterm census.
So I'm not if I get judicial notice of anything. My learned friend has not come by the proper route to put evidence which you are entitled to consider. That's what I'm making. The second defendant will be present in court. Thank you. I was again on the inability or impracticability claimed by the second defendant to complete the division exercise. We say with respect that does not justify holding the general elections on a proportional representation basis. It is a requirement of law and those constituencies do not exist.
Yes, we noted that.
Yes. And we go further to say, even if the revision exercise has been completed, they may or may not result in the delimitation of constituencies. But the exercise certainly does not result or affect an abolition of existing constituencies. It does not. So those constituencies exist until and unless they are replaced by a recommendation by the second defendant, which is approved by parliamentary resolution establishing new constituencies. That is not the case. We don't have any evidence of it. So we say it's no more than an excuse. Shouldn't be in it much. Some credence call it an excuse. It does not justify we are unable, or it's impracticable for us. Does that kill the constituencies which exist in law and they were just the last election? No. Would otherwise suppose the inability and practicability leads to the extinguishment of existing constituency. I only just have to say it to see how risible that proposition is. It's laughable. We therefore submit that proportional representation system of election to be used in the forthcoming elections in the present circumstances. Cannot avail, given the overriding requirement in Section 38A, where no constituencies exist. The population change is noted if you are not going to take judicial notice of recommendation of inevitable. Do not, the population changes do not, in and of themselves, extinguish existing constituencies. They will make a case for increasing.
Has anybody said that the current constituencies are extinguished? Did anybody see the current constituencies are extinguished?
Well, that is the presupposition.
Nobody has said that.
My Lord, pregnant and implicit in the proposal, in the statement of the second defendant. No
until they are reviewed, they exist.
Thank you, my Lord. Thank you, my Lord. Until they are reviewed and delimited or delimited out of existence.
And it does not appear to me that that is the case of the other side.
That is what?
The case of the other side.
You put in their case?
No, I'm not putting their case.
No, I just consider that they put in their case.
Of course, we read the papers. Even what you're saying, we read. So,
well, they haven't said that to you.
Bring it back.
I haven't read it yet. That may be their case. When the council come to answer, you may put it. Not without your help. The power to review and delimit constituency granted by Section 38(4) of the Constitution does not spell the doom or abolition of existing constituency. That's what you say. You may review within such a period. You may delimit the circumstances you want. Until they have been replaced or extinguished by a resolution of Parliament following your report on the review. That is how it works in law. You, Electoral Commission, you review, you note changes, you make recommendations, which form the basis of resolution in Parliament, which when adopted to establish new constituencies or abolish existing constituencies. And we don't have that. There is no resolution before. And the population changes noted may warrant new constituencies. But that is not with prejudice to existing constituencies. It doesn't make the case. The existing we're going to be more competitive. Yes, but that is not what we have. Well, that's all I want to say on the 38A and its operation, respectfully. Now I turn to the unconstitutionality of statutory instrument number 83, by which regulations were purportedly made to give effect to the proportional representation system. We say, on behalf of the plaintiffs, the defendants having been quoted in Parliament to have PR, the professional representation basis, as part of the Public Elections Act, now belatedly seek succor through the instrumentality, if I may say so, on statutory instruments, number 83. And they are both numbered 83, 83, by the way. One for Parliament, one for local elections. It's only painstakingly going through. But the Gazette and the States called them both with number 83 and number 83 of 16th November, I think. The Gazette number is there. They are both numbered 83. We say you cannot, through the medium of auspices of statutory instrument, validate proportional representation, which, as I say, the Rochford may note, was given the thumbs down in Parliament. Parliament said, no, we don't want it. And the defendant, second defendant particularly, rely on section 33 of the Constitution for its power to issue those instruments, which we say are unconstitutional. This is the anchor they want to find. Their statutory instruments on. And this is what section 33 says. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. The Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for any, for and of all public elections and referenda, and for that purpose shall have power to make regulations by statutory instrument, has to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected thereof, including regulations for voting by proxy. Unarguably, this section 33 confers power on the second defendant to make regulations. But we say respectfully, those regulations cannot change the format, form, or mode of election. They cannot, not by regulations. For the election of Parliament, change it by regulation. We say on behalf of the plaintiffs that to change the format of election for Parliament and local authorities is a deliberate matter for the legislature and not for legislation, primary legislation. For primary legislation and not subsidiary legislation. Accordingly, it is submitted to change the format and mode of election by statutory instrument, as these instruments purport to do, would be plain ultra-virus. Forgive the, I mean no disrespect, some bureaucrat, faceless bureaucrat sitting in the elite office makes regulation, changing the form, how they are going to elect MPs and local councillors. No. It is a matter for primary legislation brought before Parliament by a bill, debated and enacted by law. We mark as a footnote the defendants attempted to do that properly, but they did not fare well on the floor in Parliament. The proposal was given a thumbs down. Now you have recourse to secondary delegated legislation. It can never happen. To give an officer the power to change how people are going to vote. We can't do it. And we say further, by Section 33, the power granted to the Electoral Commission and Section 171 of the Public Elections Act 2002 is to conduct and supervise. Conduct and supervise. And not to determine the format or mode of election. You are given power to conduct and supervise election. You are not given the power to change how you're going to vote. No. That power is reserved for the legislature as a deliberate act of Parliament. We say that to change the format or mode of election is a matter for primary legislation, reserved to the legislature, and which respect cannot properly be the subject of matter for delegated legislation or statutory instrument as in the present case. The word conduct in Section 33 itself, we say, does not include prescribing the mode and form of election or changing the electoral system. The word conduct in Section 33 to make modifications for the conduct that it does not include. And therefore to do so by statutory instrument as claimed in this to change the form of election for Parliament and local government as purportedly attempted by statutory instruments would be plain ultra vires the powers granted in Section 33 of the Constitution. Those powers are limited to conducting and supervising, not to change the mode or format of elections. Section 68 of the Public Elections Act, we say respectfully, enumerates what constitutes conduct by Electoral Commission. Section 68. Nowhere in the entire Section 68 is it suggested that the Electoral Commission can, of its own volition or on instruction, change the format or mode of electoral system. The Commission can't do that. That's a matter for primary legislation by Parliament. With respect, not even the President on his own can do it. Cannot. It's there how you do it. We submit, therefore, that the power purportedly exercised through the statutory instrument is in excess of the power conferred by Section 33 of the Constitution and Section 171 of the Public Elections Act, and accordingly are ultra vires. Finally, my lords, it is respectfully submitted that Section 38 of the Constitution, A in particular, imposes conditions precedent to warrant holding any public election on a PR basis. And this is where constituencies have not been established. This condition precedent was not present when the second defendant made his press release announcing that the 2023 elections will be held on PR basis. For the simple reason that there are constituencies in the country and in the current fifth Parliament of Parliament. Finally, I say and urge your lordships respectfully to grant the relief sought by the plaintiffs in their notice of origination summons. I thank you.
Before you take your seat, sorry, sir.
Yes, Dr. Conte.
Yes,
before you take your seat, you recall I drew your article. It's not so. Initially, when you started. When you started making your submissions, I drew your attention to the reliefs. I told you there are 9 reliefs, not so?
Yes,
yes. Let me just draw your attention to relief number 6.
That's a full one.
Well, not 6,
I know there is a phone buzzing which is distracting me. I don't know what it is.
Okay.
Could you order kindly put it off? Yes, please.
Yes, the relief number 6.
Yes.
A declaration that the entirety of Section 38A of the Constitutional Amendment of 2001 does not provide
non-contemplate local council elections, the world basis on which local authorities were last elected is a subsisting and lawful basis on which any public elections involving local authorities can be held and not by the proportional representation system. My question is it the same argument? Does the same argument go for in respect of local council elections regarding section 38A?
Does that area does not contemplate local council?
Yes. But I see it has been made a leap. That's why I'm bringing it to our attention.
That's why we say they had recourse to the statutory instrument, which in our submission is ultra-violence, unlawful. You can't change the form parliamentary or local by statutory instrument. You can't.
Because you are asking us to make a declaration.
Yes.
So that is why I have brought it to your attention. So maybe you make you address us on it, even if it is brief.
My declaration is simply to say that the presidency was elected on the basis of a constituency in 2018. The second plaintiff was elected as a councillor in a ward that is still in existence in the Freetown City Council. But they now do the double take and try to do bicycle flip backwards and brought in the statutory when they realized that it does not cover. So they tried constituency, wards are not constituencies, wards form part of constituency. So they brought in the statutory instrument, which we say still is unlawful. It's ultra-violence. Section 33 does not give power to the Electoral Commission to change the mode or format of election. It can only conduct and supervise. And in conducting and supervising elections, it cannot change. It cannot go to there and say, hey, yes, you all stand behind the candidate of your choice. And the former line like it's done in other countries. We have secret ballot for a candidate on a ballot paper. Long may that system endure.
Thank you.
Thank you. Thank you, Madam.
My mind is. Thank you, Dr.
Madam, I had written a reply and answer to the objection. I can forward it to the court, give a copy to my learned friend, because I treated it in my submission on the motion. 53 subsection 3 does not avail. It cannot shield.
I think you ran a bit.
No, I thought elaborately I was going to move the objection, so I had prepared a written response. But I think I took it in my stride in moving the motion. Unless you want to hear any more on it.
We'll allow the other side to make their submissions now.
Thank you, my lords. My lords, I would want to crave the indulgence of the bench as to how we address our case. We're seeking leave, my lord, for two counsels to be had. Basically, we have divided the issues and we have certain declarations that we want to address specifically, especially the one dealing with jurisdiction. We intend that will be handled by Kanu, and there is the substantial issue about interpretation and the constitutional instrument, which I will deal with. My Lord, on the sequence of my presentation, I will further seek your leave to firstly deal with the constitutional instrument, which I am likely not to spend much time on. Maybe 10 minutes maximum. The constitutional instrument, Lord, or purported constitutional instrument, so to speak. Sorry. The instrument. May I proceed? Yeah. My Lord, firstly, we maintain and uphold our submission file in our case. In our case 5, that is on the 8th of December 2022. Specifically, paragraphs 18, 19, and 20, they are reading. And we'll draw the court's attention and possibly style it in our own way to say that is a preemptive strike. A preemptive strike. Even from the submission made, as at the time of filing, that instrument was not law in our country, or the purported instrument was no law in our country. An instrument was laid before Parliament, and there are parliamentary procedures to challenge any instrument laid before Parliament. And those procedures I submit based on the case of SC number 2 of 2005, that's the case of Samuel Norman against Dr. Sama S. Banya and others. of the Honorable Justice Tola Thompson of blessed memory, dated the 31st of August 2005. Wherein unreported, that this court, my Lord, cannot inquire into parliamentary proceedings. I further rely on Section 94, specifically subsection 2 of the Constitution said, and it was during the interim, Section 94, 2 of the Constitution. A document was laid, and in the interim, an application filed. And that document is a statutory instrument. My lords, as I speak, in that application, no certificate of maturity of that document was filed. No certificate of maturity of that document was filed. I will further invite your Lordship to take judicial notice that the certificate of such document was subsequently issued on the 19th of December 2022, long after the filing of the application. Certificate of maturity was issued on the 19th of December 2022. I further and finally state that maybe what matured on the 19th was not what the plaintiffs are speaking about. If you look at their case, my lord, it is titled The Unconstitutionality of Statutory Instrument number 83 and 83 of 16th November 2022. No such document exists in Sierra Leone as I speak. Not even as a proposal, neither as a law. It was published in the Gazette based on what is exhibited, and it is statutory instrument number 13 of 2022, which was published.
I'm sorry. I thought you were talking about it. You were saying now what was published was what?
What was published is statutory instrument number 13 of 2022. And the argument here is centered around statutory instrument number 83 and 83 of 16 November 2022. I'm saying there is no such document.
Can you please go back?
do you mean by no such document?
83, statutory instrument number 83 does not exist. What exists is statutory instrument number 13, if I may add, and 14 of 2022. We must be thorough when we come to the Supreme Court.
And what is now in existence?
What was published is statutory instrument number 13 and 14 of 2022, dated 16th November 2022, and the not statutory instrument number 83 and 83 of 16th November 2022. I have been searching for that since the application was filed. The date is 16th November 2022, and it is statutory instrument number 13 and the second number 14, and not 83 and 83. And this is a court of law, my lord. I read my case with respect to that argument. I say no, unless you want me to answer any specific question.
Well, I mean, look at what was exhibited in the case. What was exhibited?
What was exhibited is statutory instrument number 13.
Yeah.
And the argument profiled here is dealing with statutory instrument number 83.
Well, in the bundle of documents, in statement of case, you have what is the correct version. In the statement of case, and in the bundle, in the statement of case. In the statement of case.
I do agree. That is why we are saying we are not sure that the document that is in their bundle is the document they are discussing or arguing.
No, probably there's a terminal error.
Then that should have been corrected. They may be talking of something which is not before
general. You have self-insulation of 13 there. That's good. You have it.
It came into being on the 19th of December, not at this time. There may have been changes when it went through Parliament. We don't know what exactly is in here. It's what we have as law.
The one which is law is different from what you have there. What was exhibited in the statement?
In words and in phrases, I have not checked word by word, phrase by phrase. I have not done that.
Okay, if you find out there's any difference, let us know.
My lord, the first difference maybe is date of maturity. In fact, I would want to refer your lordship to.
You see why I'm saying this is because sometimes we know the date, sometimes particular additions are being in place because we suspect. I know that is a matter of power.
I do agree, my lord. That is why when we come before you, this is the highest court in the land.
Yes.
And I will refer your lordship to section 170 of the Constitution, subsection 7 thereof, which tells you the procedures. And that clearly states how statutory instrument becomes law. The law is in your bosom, my lord. I need not waste time on that. But all the arguments here this afternoon was based on statutory instrument number 83 and not what has been filed.
You said just now that what was exhibited is the statutory instrument number 13 and 14. I see no exhibit on that.
It's about 13, only 13 was exhibit. What was attached to their statement of case, not exhibit, sorry. It's attached to the last document at the back.
No, I cannot see it in my document here. I cannot see it.
Register.
Well, Mr. Kowa, the submission, the content submission involves around 52 and 83. Not so?
83,
83,
which I say does not exist inside me. If we refer to the wrong law, my lord, we're referring to the wrong law. No other way. The wrong document is the wrong document. This is written and it was
So what is dated 13 and
13 and 14. And this application was filed sometime in November. And today is the 9th of January. And we are lawyers.
Yes, Dr. Abdullah, you wanted to say something.
Whatever the numbering of these rights, we did not make them. The thrust of our case, that the Electoral Commission has no power under Section 33 of the Constitution to change the format as that instrument by whatever member called to change the format.
We know your argument. Your argument is clear. There's no need to emphasize it. It's clear.
This last argument.
It's just to make sure if even the court wants to turn its attention to consider that document to ensure that what we are discussing we're all on the same level, not something different. This is what we're talking about, legality. And what is in Sierra Leone is 13 and 14, which became law long after the application has been filed. I will further proceed. My lords, in all of the arguments,
Before you proceed, colleagues, do you have number 13 and 14 attached to the statement of case? I need you to check it now. Second defendant.
Sorry, madam.
You exhibited it. That's what we have.
No, we did not. We did not. They exhibited
the second, the respondent is the Electoral Commission, it's not you.
Yeah, if you look at the bottom of 5 by the second defendant, that's why I said to you.
Well, I don't know. They are saying they did not exhibit anything.
I don't know what we have here. Check this water.
The plaintiff exhibited one statutory instrument, which is
okay. We'll move. Let us move.
You know that some classes there was no, this is
as my brother.
You can see there, this is just by anyway.
Move, let us vote.
Well, we've addressed the 9th relief prayed for, and I shall be addressing the other reliefs, to wit, the 4th, the 3rd, the 4th, the 5th, and the 6th.
First, 4th, 5th, 6th.
Yes, jointly. I'll be addressing those needs jointly on behalf of the first person.
Yes.
We heavily rely on our case time. And with respect to the trust of the interpretation sought before your Lordship,
The trust of the
interpretation sought vis-a-vis section 38A the trust of the issue is whether there are existing constituencies which obviously could not trigger a direction that would lead to the PR system. What has not been analyzed in the plaintiff's case, my Lord, is the proper and complete reading of the provisions of section 38, in this case A. Section 38A. And with your leave, my Lord, if I may read so I place the necessary emphasis. Section 38A says, we are under any law for the time being in force.
Is that what it says? It says 38A. Then you jumped something there.
As my Lord pleases, let me.
It's 38A1.
38A1, if I may clearly state. So, A1 says we are under any law for the time being in force. A date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection P of section 38 for the purpose of such elections. For the purpose of such elections, the president may. It is clear from our case, my Lord, a date has been appointed for all elections that may want to be brought. And for the purpose of those elections, the date has been announced. In this case, it says such election.
We look at elections in contemplation.
In contemplation, my Lord.
Which elections?
Between June 20, 24, 2028. Sorry, my Lord.
In 38-1.
38-1.
2001, which elections?
My Lord, that is, I am just giving flesh to 38 because in this situation, in the invocation of 38, my Lord, it is not talking, when it says such, it's talking about futuristic approach. This has been announced. And for the purpose of elections that will be held based on those or that announcements.
Is asking a simple question. Which elections are we talking about?
Now, in this situation, is the June 24, 2023 election.
For what?
Members of Parliament, members of Parliament. At this stage, I will limit myself to members of Parliament. I shall be dealing. There is a specific order with respect to local council which was raised by Justice Alusani Sisi. My Lord, such elections are to be held on the 24th of June. The date has been announced. Now we find ourselves in a position wherein there has been a midterm census. And the issue of the census is dealt with in section 38 of the Constitution. And the census results published. That automatically alters our figures. In the population density. In the population density. And it is very clear in the Constitution, my Lord, when you read section 38, subsection 3, together with section 38, subsection 7.
Referring to section
38, 3 and 7, my Lord. These are sections that deal with the inhabitants and the population density and the review of constituencies. I do not want to engage myself in reading the Constitution. constitution line by line and the rest of it. Further, my Lord, I would want to fortify my argument in relying on, especially the documents which are attached to our case, by relying on Rule 92. Because the census results published are attached, and Section 92 is of the Supreme Court rules very clear that what we need to do is to attach documents, and as long as we file an affidavit verifying our case, and nothing more. And that we did.
If I may ask, is there any relationship between Section 38 and 7?
My Lord, I will crave the court indulgence that these sections should be read together. You don't just read them in isolation. Otherwise, the essence and the effect. Yes, ma'am.
They should be read objectively.
Yes, ma'am. To be able to have the proper meaning and gaps of it.
That's your assertion. You cannot.
That's my submission, my Lord.
Yes, you cannot see that if you read it.
My Lord, Section 38, 1, 2, and 3 are mentioned in this situation. 3 states, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. The proviso says, provided that the number of inhabitants of such a constituency may be greater or lesser than the population quota, in order to take account of means of communications, geographical features, density of population, our emphasis, density of population, the distribution of different communities, the areas and boundaries of the chiefdoms, and other administrative or traditional areas. This is very, very important. And 4 terms shall be reviewed. The Electoral Commission shall review the division of CELLE into constituencies at intervals of not less than 5. That I'm sure is not a complaint there, the submission here that has been correctly done. And the proviso is very clear, they are on that. And I may really say, provided that the Commission,
Go to 7.
for the purpose of this section, the number of inhabitants of CELLE shall be ascertained by reference to the latest census of the population of CELLE, held in pursuance of an act of Parliament, or if no census has been so held, by reference to any available information which, in the opinion of the Electoral Commission, best indicates the number of those inhabitants. We now see the relevance of the census together with the issue of constituencies review and delimitation. This is the connection. And I must be quick to say, it talks about the latest census.
I certainly cannot see any connection between 3 and 7. I must see the
Number 3 deals with constituencies boundaries and the inhabitants thereof. When it comes to the issue of reviewing constituency, to be able to determine the population density in a particular area. If you look at the census results, my Lord, it tells you about the population density in different areas. There has been a tremendous shift from 2015 to date. And 7 is directed as to how the mathematical calculation, the numbers, should be done. That is why I am relating these sections with the latest census results. That is the guiding document that will assist the Commission to be able to review the constituencies.
You got the latest census
the one that was used, my lord.
Which guidance we process the latest census?
Unfortunately, I don't have it here.
I don't know. I think
there was an act, my lord, as opposed to 2015 when the census was done by proclamation. In 2021, there was an act, and it had census.
Well, that's the act.
There was an act. Now, that is the relation I am establishing. That is the relation I am establishing. And it is this result which will necessitate a review. It is this result. I am quite sure that the second respondent will do an analysis with respect to some other issues dealing with the publications of the census results and the date of elections which has been announced. I don't want to delve into that at this stage, madam.
Yeah.
Therefore, we are saying, with respect to 38A1, my lord, the date which has been announced deals with the election, in this case, the elections which have been, which is to be held on the 24th of June 2023. Otherwise, you cannot announce a date for an election which has passed. You cannot, my lord. You only announce a date for a futuristic event, and that has been done. The need that the review should be done and it's not done with the issue of the reasons or whatever, that is not why we are here, to give reasons why constituencies were not reviewed. That is not part of any of the application or the relief. Hopefully, then we want to assist the court, but that is not part of the relief. Grateful. We are here based on the fact that the constitutionally elected president has acted in accordance with the law. If there are no possibilities, the Constitution makes provision, and that's he has exercised. The issue of his authority to deal with that will be dealt with by Mr. Kano. So the interpretation, my lord, given by the plaintiff is limited, since the argument put before this court is limited to war situation. That was clearly said, and it's in the document, that the provisions will be invoked when there is war. That, I submit, was not the intention of Parliament, because we're not praying for it. Sorry. Now I'm referring to the submission.
Well, I don't think it's saying people should express that. What you said was that it was done at that time. That was the comment. You give it context. That's when it was
And then it was not the war. Maybe all those past during that time, my Lord, we could not relate and say, because we were past during the war days, they deal with those situations only. I am submitting that they are not limited. Otherwise, the drafters would have clearly stated that. They would have clearly stated that. And it has no business still to continue to exist in our Constitution. It has no business if that was specifically made for that period. It has no business to still live with us. And it is a constitutional document and it lives with us. One may understand when you say in circumstances wherein there are situations where the consequences will not be reviewed. You invoke that provision. And that, I believe, is what has been done. It does not specifically state any circumstance. This is for this court, my Lord. That taking into consideration. Sorry.
I hope my learned friend understood my say again the provenance of proportional representation community. It has its origin in the military decree of 1965. And then because of the war situation, I'm not saying that 81 was geared to a war situation. I didn't say that.
We pointed that out for you.
No, I didn't say that.
Thank you, madam.
Now, those situations that we could use 38A1, my Lord, are not clearly itemized in the Constitution. And one thing I want to draw the court's attention to, my Lord, Constitutions are meant to stand the test of time, necessitating the doctrine of posterity. Constitutions are not made just because of the situation today, and after that situation, we forget about it. This is a constitutional provision. It has been here since it was amended, and it still continues to live with us. And posterity today is telling us that even in economic and crisis situation, even in time management situation, you could invoke a provision, especially when the Public Elections Act, which has just been passed, has adopted the ECOWAS protocol, which tells you you cannot amend legislations 6 months towards an election. They may have been fought by that, and constituency review and the limitations, my Lord, definitely is a very serious amendment in any law in any country when elections are approaching. We have to be very careful with that. We have to be very careful with that.
Are you making a submission?
It is a submission now. I submit, my Lord, that the Public Elections Act and the ECOWAS protocol which are with respect to good governance, very clear and mindful about legislating
Submit on the Public Elections
Act, my Lord, of 2022 and the ECOWAS protocol, my Lord, limits legislative amendments with respect to electoral laws. With respect to electoral laws. 6 months towards the election. It is therefore in fairness, good governance, in fairness and good governance, not to have attempted to proceed with any law, in this case, review of consequences in the law. And possible delimitations of those consequences those consequences which have been reviewed. Based on the latest census results, which have been announced, and the appointed date for such elections. But further, I realized that my learned senior and to according the respect of former Honorable Justice or Chief Justice, was very quick to address you that on the issue of locals with respect to independent candidates, that he holds no brief for them, if I'm right. I wonder whether I based on that since he himself has admitted, because in the argument he spoke about independent candidates. I am of the view that had it been a situation wherein any independent candidate was challenging any issue, they would have been before this court. But those who are before this court have won a political party. I don't know if your Lordship wants me to still address that. The argument for independent candidates could not stand before this court, as he himself has admitted that he has no locals to defend. Sorry. My Lord, I must say that firstly, that issue which has been raised has not been complained of by anybody. Has not been complained of by anybody. And assuming the court wants to turn its attention to that issue, the statutory instruments that matured on the 19th of December makes adequate provisions for independent candidates. Adequate provision. That is why, in fact, nobody comes in. Most of those who intend, I'm sure, are satisfied with the provisions. That is statutory instrument number 13 and 14. Sorry, may I just... Number 13, statutory instrument number 13, section regulation 10B thereof makes adequate provision. With respect to nomination, 10 states, nomination of a candidate shall be in the case of A talks about political party and B talks about independent. Nomination of a candidate shall be in the case of an independent candidate in accordance with section 58 of the Act. Provisions for them to be nominated. We will adequately consider.
Don't forget that the measure of name involved what the customer offer.
Justice Gambart has asked me to address this issue. That is why I am.
Now here's the good news. Sierra Leone Commercial Bank operates in 4 money.
This song come up from Madam Sidra to Aminata Kamara from the United States of America. It is dedicated this song to one of the biggest organizations in the world, WEARD. Yeah, made a crack on the mix. 91 big boy picking.
It's your double tap, see the ball. Daily days, 091. Yellow flag in this.
Hallelujah.
Come on now. WEARD organization. Don't come for every nation. WEARD organization. Don't come for promote the nation.
But I am sure there are modalities for that. I don't know whether Dr. Safa Abdullah, who is representing NEC, will be able to tell us the various administrative procedures which one will have to go through. But the law, as far as it is concerned, make the necessary provision for the involvement of independent candidates. It does not stop them. And prior to the passing of these legislations, there was nothing for independent candidates with respect to nomination and the rest of it. It was barely left with the Electoral Commission to devise the means based on which they will be nominated. The Constitution only spoke about independent candidates once, and it tells you that if you went to, in fact, it did not tell you how you go to Parliament. It merely says when you go to Parliament, you cannot switch. You cannot cross. This is what happened, and they have been going to Parliament. So I believe NEC, in their wisdom, knows how they will go. Right, my lord? And my lord, the Constitution again, section 75, is very clear on this issue. And it tells you the qualification to go to Parliament. They are very clear. It does not say you must belong to a political party. Yeah, not to parliamentary. We know that. Yes, my lord. It tells you your age, your Sierra Leonean nationality, and I am sure this was well dealt with in a recent case that was before the Supreme Court. Carry on. Let us move. Let us make progress. My lord, that is in respect of that document, and we still insist that the preemptive strike document which was filed, albeit in an intention to disrupt or interfere with the parliamentary procedures, could not stand and should not be countenanced by this bench. This is a bench that does not look at proposition, not a proposal for parliament. You cannot look at a proposal for parliament. The responsibility to the Supreme Court is with respect to substantive law when it comes to the issue of interpretation. We cannot interpret a proposed document to do what? Of what essence would that be? And this court cannot act in vain. It cannot. In fact, I was thinking before coming here that there would have been another application and this one withdrawn after the 19th of December. But we still have the same old application. It may be a dangerous precedent.
One that was filed on a preemptive basis. I'm referring to the law as it is.
Suppose we were to have a list, they will not be part of that. One can be one. That would be a list.
The list of my Lord, the list is not a situation where based on list you will be eliminated. You are an independent candidate and there are only 3 voters that will nominate you. You go to NEC, I'm sure those are administrative procedures for the forms and everything. It is not based on political party. It is based on generally to be elected. So
in essence, what are you saying? Are you saying that if you are an independent person standing in election, what would be like the threshold point? The moment you have been mixed up with the list. Now, those are issues that
I do agree that there are times individuals misunderstand that list.
What's the threshold? What is the threshold? That is not the essence we say. What would be the threshold in that kind of situation?
Yes.
How would an independent person be a member?
My Lord,
there's a list.
The list is not talking about, in this situation, list of political parties. It's talking about you have 3 voters nominate you, and there is a form which they will use to nominate you. In this situation, my Lord, once I am of the view that I am not an expert in electoral processes, but I am sure there are modalities for that. I don't know whether Dr. Safa Abdullahi representing NEC will be able to tell us the various administrative procedures which one will have to go through. But the law, as far as it is concerned, provides make the necessary provision for the involvement of independent candidates. It does not stop it. And prior to the passing of these legislations, there was nothing for independent candidates with respect to nomination and the rest of it. It was barely left with the Electoral Commission to devise the means based on which they will be nominated. The Constitution only spoke about independent candidates once. And it tells you that if you went to, in fact, it did not tell you how you go to Parliament. It merely says when you go to Parliament, you can switch. This is what happened. And they have been going to Parliament. So I believe NEC, in their wisdom, knows how they will go. Right, my Lord? And
lacks jurisdiction to grant the second relief. My lords, the ultra-vires doctrine that the plaintiff have raised under the second relief deals with the excess of powers, my lord, of decision-making bodies. Ultra-vires doctrine that the plaintiffs have raised deals with the excess of the powers of decision-making bodies.
We are saying that they acted arbitrarily.
In this case, the president acted arbitrarily. In other words, they acted beyond the powers granted to him under Section 38. That's the issue here. Lords, I will additionally submit for this honorable court to grant the second relief prayed for. Come again? For this honorable court to grant the second relief prayed for in the originating notice of motion, the following has to be done, my Lord. That is to say, this honorable court will have to first interpret Section 38A of the Constitutional Amendment, to determine the scope of delegation of power, then to determine, then to interpret, the delegated power in question, and finally to adjudge whether the same is within or outside the constitutional amendment, or exceed the scope of authority given by the said Section 38. So, my lords, it is my submission in a nutshell the underlying effect of the second relief sought is seeking for a declaration by this honorable court. The underlying effect of the second relief, my lords, is seeking for a declaration by this honorable court that His Excellency the President acted outside the constitutional amendment or jurisdiction conferred herein. In a manner which is procedurally irregular and therefore acted ultra-vires of his powers. The Constitution of Sierra Leone has not conferred this power with respect to this ordinary court. My Lord, I refer you to Section 53, subsection 3 of the Constitution of Sierra Leone. The Constitution of Sierra Leone has not conferred this jurisdiction to this honorable court.
Plaintiff have raised under the second relief.
And more. Our media services include broadcasting, media production of
where whether by this constitution or under any other law, the president is required to act in accordance with the advice of any person or authority. The question whether he has in any case received or acted in accordance with such advice shall not be inquired into in any court. Lord, the second relief is asking this court to inquire into the directive of the president. That's what he's doing. And I believe my learned colleague, who I believe Abdullah Conte, who is one of the proponents of the 1991 Constitution, the new dispensation as it was hailed at the time, definitely has attempted to address you on this provision with regards to ouster or exclusion of jurisdiction. It's clear, it's there. And a similar provision that the Solicitor General has addressed you on earlier, similar to that, is 94.2, which is again clearly mentioned in the case of Inga Norman that Malane colleague cited earlier. My Lord, the ruling of Justice Tola Thompson, now late, in this matter at page 320 of that ruling, stroke 9, is instructive. Lord, if I may read that ruling for you. It says it's a rubric jurisdiction. It says jurisdiction with reference to a country's judicial system simply means the authority which a court has within the system to decide on matters litigated before it. It is usually conferred by the constitution of that country or statute. Therefore, if a constitution of a country states that the court has no jurisdiction in certain matters, it is impossible for the court to assume jurisdiction on short matters. See Ohinimo versus Akasati to Waka. My Lord, he went on further to say, there is also the point of exclusion or ouster of jurisdiction. This is the removal from the courts of its power to hear and determine the issue. In some jurisdictions, the exclusion clause is incorporated in the constitution of the country. For example, Section 94, subsection 2 of Constitution forbids any act done under the rules of parliamentary procedure shall not be inquired into by any court. My Lord, the end words of Section 53 clearly says the act mentioned above shall not be inquired into by any court. Similarly, Section 53(2) is saying the same, my Lord. Yeah.
Yes. I look at the result.
Yes, my Lord.
The emphasis is where the extant and subsisting constituencies is ultra-vires the constitution.
Yes,
it's not on the directive. They are not. His argument was not saying that we are going to inquire into whether the directive was given or not. No. He's saying whatever directive may have given, whether consultation or not consultation, which cannot be inquired into, because where the extant and subsisting constituency, it is ultra-vires. That is the point. He says a declaration that the directive by the President to the Electoral Commission of Sierra Leone to hold any public elections for ordinary members of parliament by the proportional system where there are extant and subsisting constituencies is ultra vires the constitution.
My Lord, you cannot reach that conclusion without looking into how that directive was given. It's the how. And for you now to declare that directive ultra vires, you have to look at the circumstances that led to that directive. That's what 53 is triggered. You have to inquire into it.
I think what they are saying is not so much whether they acted in accordance with after consultation. One, there are already constituencies. Two, what's the second category? There are already constituencies.
Yes.
It's fixed for the election.
Lord, I think the issue of whether there are extant constituencies or not, it again goes to the substance of the case, which I believe...
That is something we're going to handle.
Exactly.
That is
what we are saying.
That is what we are going to handle. The directive as it is.
It's reference to the directive. Because if it was an issue of whether there are extant constituencies or not, it is the issue for both parties here, the defendant and more particularly the second defendant, to show that there are no extant constituencies, because what they are alleging, there are extant constituencies. But again, we have stated in our case, the implied or expressed effect of 38(3) and 7 means, and the recently concluded census, that there are no extant constituencies. That is for this honorable bench.
That is a question. That's the declaration we are going to answer.
Definitely.
Whether the extent or substance, we'll look at it. But to make it reference to 53 is my point.
My Lord,
the issue about inquiry, it does not apply here.
It's the way this second relief has been drafted. If, in other words, you hold that directive is ultra vires, my Lord, the President has acted illegally. And if you investigate into how that directive came about and you decide to hold, well, I don't want to mention the constitutional consequences. Then 51 will be triggered, because as a custodian of constitution, he has breached the constitution. I think there are reasons behind these provisions.
Okay. Proceed.
And I know my learned seniors mentioned the English case of Lord Hill, talking about parliamentary supremacy. Unfortunately, the UK does not have a written constitution. We have a constitution, and we are bound by our constitution. It's simple. Unfortunately, I mean, my time at studying government and politics, one of the interesting things about the UK is the lack of written constitution, which you have to find within different statutes. It does not have a written constitution. We have a written constitution. And this court sitting at this very moment is a constitutional court. And constitutional provisions have to be applied, albeit, however unfair they might be. So, my Lord, we are saying, having read the judgment of Justice Fowler Thompson, I'll submit that the Constitution has stated clear and unambiguous words, that is the exclusion or ouster of jurisdiction by the removal from this honorable court of its power to hear and determine the second relief sought. I respectfully submit, my lords, that the only jurisdiction left for the second relief is for that relief to be struck out. That is all I have to say for the second relief, and I want to address you on the seventh relief, the restraining order. I know my learned senior has not dealt with that.
Yeah.
My Lord, I submit that the second relief is a consequential relief. What? It's a consequential relief, my Lord. Seventh relief. Which I believe flows from the second relief, my Lord, if it's granted. As I've already stated that the court lacks jurisdiction to grant the second relief, my Lord, I'll respectfully submit again that this seventh relief should be struck out in the event that the court holds that they lack jurisdiction to grant the second relief.
Are you with us?
My apologies, my Lord. My Lord, now that the plaintiff have actually now stated their case, we want to draw you to an attention dealing a reference dealing with section 89. I mean, I think it's an opportunity for maybe this court to look at it, maybe the wording of Rule 89 of the Supreme Court rules with regards to the affidavit.
Yeah. 89 of the Supreme Court.
Supreme Court rules, my Lord. 89 sub rule 2.
Yes.
My Lord, 89 sub rule 2 said that the notice of motion shall be supported by an affidavit setting forth as concisely as possible the nature of the relief sought. My Lord, our contention here is the affidavit filed together with the originating motion, notice of motion have not concisely set forth the relief sought. Yes, the reliefs are in the motion, but the reading of this section, affidavit setting forth as concisely as possible the nature of the relief sought. There is nowhere in both affidavits that has been met. So, my Lord,
but that's a non-compliance issue. Are you relating it to jurisdiction? Is that what you do?
My Lord, it depends on how you hold with regards to this. It's just for us to raise it to you. I mean, it's a non-compliance issue. It might be mandatory or directory, but it depends on how you hold. But I think I anticipate your ruling in this.
Make your submissions. If you're making your submission, make your submission.
My Lord, my submission is that the plaintiff have not complied with this provision with regards to the affidavit, my Lord. And I invite this honorable court to so.
Plaintiffs
have not complied with the provision of 89.2 with regards to the affidavit, having setting forth concisely as possible the nature of the relief sought. That is my humble submission, my Lord.
That is all I have to say. My Lord, unless you want me to address any more issue, that's a case for the first defendant.
Second respondent. Excuse me, what's the time now? It's 1:45. Can we take a 10 minutes comfort break? We'll come again at 2.
Sorry, Milan.
Can we take a 10 minutes comfort break?
Of course, Milan.
We'll come again at 2. Pardon? 20 minutes. It's 1:45. Perhaps my time is fast. I don't know, but will you please rise the court for a 15 minutes comfort break?
This song come up from Madam Sidra to Aminata Kamara from the United States of America. It is dedicated song to one of the biggest organizations in the world, Weird. Next one big way begin.
It's your double time to see the ball. Daily base, 091. Hello, Platinix. Come on. Weird organization. Don't come for every nation. Weird organization. Don't come for promoting nation. They know they mix my politics. They know they pass tribalism. They know they mix my politics. Yeah.
no can now we land. So love it all and fine. Who know they back kapu kapu? We are no big spark kamu bamua. We know they back kapu kapu. We are no big spark kamu bamua. But tell the brother sister them say we are don't come we are now we are. Tell them for me say we are don't come